We're back, everyone. News and Talk 1380 WAOK, Real Estate 101. I'm Mary Gill. Althea DeBar-Johnson, the state attorneys of Atlanta, is in the studio. Love having these conversations. Let's talk. Let's enlighten the listening audience about the Lis Pendens. We can't leave them hanging like that.
Right.
Okay. Right. You can talk about how you use it. I'll talk about how I use it.
Well, most times I use it just to place other parties and the public on notice that there are pending litigation, the possibility of pending litigation, or just like you, there is a debt due to someone.
Correct.
Not necessarily me all the time, even though I do like you do sometimes, but in this situation, someone needs to be aware of the fact that there's possible litigation, because even though we do have some closing attorneys who will do their due diligence, every once in a while you get that closing attorney that just goes off to the left field. I've had that to happen.
Well, and so how we use the Lis Pendens is when someone has defaulted on a contract, everyone hear me, and they owe a commission, and they've decided to do, typically what happens, guys, I'm just going to tell you, is that, especially with today's investor markets, or recently had one with a husband and a wife, when they decide to cancel the contract, your contract that you have worked on, and they do it by defaulting on a contract that you're currently in to sell the property.
Wow.
Okay? And trust me, it happens more often than we like. And that those parties, one or the other, owes a commission to me, and really the other agent who brought the buyer, if I'm representing the seller. But we're both owed a commission. Well, we can't stop them from doing whatever they want to do. And we can't stop them from saying we're not going to pay you. It's happened recently. But what we can do is we can stop you from doing anything with this property.
That's right.
So what I do is I go immediately and file in magistrate's court a small claims action against that person for defaulting on the contract.
Sure.
And then I walk right over
to the property department.
Property department. And I file the Lis Pendens, because you cannot file the Lis Pendens unless you have an action that has been filed. So I file the Lis Pendens, and that is filed against the property. Now, guys, that property 90% of the time cannot be transferred or sold without
your debt
satisfying
the
action that is currently out there, because it puts everyone, like you said, on notice. And the closing attorney, if they try to sell it without you and not pay you, it puts the closing attorney on notice that there's pending litigation.
Right.
Now, in doing research, the closing attorney can, in their discretion, ignore your Lis Pendens and still close on the property. However, here's why 99% of the time that doesn't happen is because the owner needs to get title insurance, okay, on that sale, on the property. There isn't a title insurance company in existence that's going to ignore that Lis Pendens.
Right.
Because they're taking on the liability of any liens or encumbrances against the property if you close and it's insured. So all of these things are satisfied prior to them moving forward and doing anything else.
That's right.
And it draws them into court.
Right.
Because they cannot move forward with doing anything with the property until this action has been satisfied one way or another.
One way or another.
Now, normally we win. However, I did have an instance whereby we made a claim against an estate.
Mm-hmm.
This was just the administrator of the estate just ended up using the technicality
Mm-hmm.
against us. And I did have an attorney, but they used a technicality against us to dismiss it because we did not establish a debt. We brought the claim, but we did not file it as a debt against the estate.
Okay.
So now I would have had to go all the way back and file it as a debt and then re-bring the action and all that stuff. And it just really wasn't worth it to me. You know what I'm saying?
Sure.
Because I knew that these people were just being manipulative to try to get out of the debt. And I said, I'd weigh whether or not it's worth it or whether it's not worth it when
That's true.
when I move forward with
Mhm.
something. So
Yeah.
anyway, I just let a lot of times I just let
Yeah.
God straighten it out. Let karma come and do its business. But anyway, but that is how you are able, everyone out there. So do not try to take matters in your own hands and try to go file a Lis Pendens and file an action and all that stuff, because in the end, once it is you do have to go to court, and when it's rectified, you do have to remove the lien and all of that
Right.
against the property. So there's a real legal procedure, and unfortunately, we try to avoid paying an attorney just a little bit of money
Just a little bit of money.
to do it the right way.
Right.
All right, so we've established if someone dies without a will, which is a ton of people, unfortunately, then it is called intestate, which means we don't have a will.
Right.
And now the laws of Georgia kick in reference to the distribution of assets.
Absolutely.
Okay.
And yes, they have a list of who receives first. So again, if you have a husband and wife and there are no children, then the surviving spouse will receive. If there's a husband and wife and they have a child or children, then whoever's the surviving spouse, it would be the surviving spouse and that child who will share in that the deceased person's estate. Understand, you as the surviving spouse do not take it all when there's no will. So you share that with those children. If that child has passed away, then it goes to the grandchildren. Okay? So it just goes down, it basically goes down the line. And there's other outline, or the state of Georgia outlines who it should go to next. In the event you don't have children, you have a situation where you have parents who may be alive, or you may have aunts that are alive, grandparents that are alive, but it just depends on your circumstances. So when there's no will, it goes to someone. Hopefully it goes to a relative, and we do not end up having to pay that money to the state of Georgia.
So let me ask you this question. This has always been an unanswered question in my mind in reference to how it's distributed. Let's say there are 6 heirs and 2 of them have passed away.
Mm-hmm.
Okay? One did not have children. So, of course, his portion goes to his brothers and sisters.
Of course.
Is there a way that you can file a document to combine it as opposed to someone now having to become administrator of his estate in order for his portion to go to his brothers and sisters? You see what I'm saying?
Right. Affidavit by descent. So we have this document. Basically, it's a affidavit stating that this sibling passed away. He or she did not have any children. And so someone in affidavit, just attests to the fact that this is what it is.
Right.
In Tennessee, One of the officers was in critical condition after two police vehicles collided last night in Maryville, that's near Knoxville, where Vance was in town for a fundraiser. The Tennessee State Patrol says a Maryville officer on a motorcycle was involved in a crash with a state trooper. Both were taken to the hospital where the motorcycle officer was listed in critical condition. There's no word on the trooper's condition. Millions of people are under a flood watch in Southern California as an atmospheric river slams into the coast. More from Daniel Martindale.
That's what the National Weather Service is projecting. Downtown LA is expected to see more than 4.1 inches of rain by early next week. Downtown averages about 17 inches of rain per year. The foothills and mountains could get up to 5 inches of rain, causing concerns for the recent burn scars.
Over 20 million people in the LA County area could be affected. You're listening to the latest on NBC News Radio.
Good afternoon. News and Talk 1380 WAOK. Real Estate 101 is happy to have in the studio Attorney Althea DeBar-Johnson. We're talking probate and everything that entails. But we have a caller holding. Let's talk to Johnny. How are you doing, sir?
Hey, great. Hey, thanks for having her. I remember her years ago. But anyway, I appreciate you spending your time just coming over here to help us out in these situations.
It's my pleasure.
Nice to hear that.
It's my
You're
pleasure.
welcome. Yeah, so I talked to you years ago, but my mother passed probably like a little over 2 years ago, and so we do have a will. My sister, I guess she wanted some money, so she got some money, like $26,000, and she moved out the house. They all was living in that house. All right, so now we're going to have a appraisal or inspection. I think it was inspection, but my sister I have two sisters that was living there. They had too much stuff. So the guy said, hey, I can't even do an inspection. You have too much stuff in these rooms, and you need to get it out. So when we tell my sister, she's not living there anymore. I still have one sister that's living there. And I said, hey, you need to move your stuff. And she never moved her stuff. So my, what do you call it, the lady that my other sister that's responsible, executive, I guess, went on and said, I think she talked to her attorney, maybe talked to him, and maybe they told her what to do, and she sent the letters. But my sister never responded to the letters. And then I said, hey, so here we are now, 2 years later. She still got her stuff. I went down there and got him out the room and took it down into the basement. And I told my sister, let's just take this stuff to storage, pay for the storage, pay maybe 2 months for the storage, and then, hey, it's not on us. But my executive sister, she's worried about my sister suing them in some sort of way, And then my other sister that's living there, so I have two sisters living there. She said, well, I'm not going to get my stuff out until Marianne, which is the one that moved, out. You know what I mean? Okay, so I went, like I said, moved all this stuff downstairs in the basement. It's like it's a basement, almost like a crawl space, but it's a bigger, 1900 house, nice house. And so now, even if I get my sister to move her stuff, I just wanted to say, hey, take it to storage, that kind of thing. I still got the other sister in, and I can tell she's not going to, I'm going to have the same problem with her. So this is where we are. And do you think after 2 years, I can just take my sister that's out, take her stuff to storage, pay 2 months, and just get it out of there? What do you think?
Well, it sounds like to me it's abandonment of property. I mean, if you're giving her notice about moving her things out and she hasn't moved it yet, that sounds like abandonment. I'm not sure what the time limit is on it, but it sounds like it's abandonment. I don't know. The sister who is the executrix of the estate may not be as proactive as she should be. I'm not sure about that, but she needs to do what is necessary to close this estate out.
Right.
You can't just continue to linger on and not do anything, not perform your duties as a fiduciary, as the personal representative of this estate, because what you failed to do may harm the estate. And that is something that can find her in contempt. So you just can't just linger on forever. You have to be as proactive as you possibly can to settle the accounts and the business of the estate so that you can close this out and move on.
Gotcha. All right then.
I mean, values are going down. Property values are going down.
Yeah.
So, but if you could have sold it a year ago, you would have gotten more money than you would if you sold it now. And I just go.
But in California, the property where we live at is going up. Believe it or not.
Oh, good. Well, that's good.
Yeah.
But here's the thing. This is what my first question when you started this the story is that an appraiser should not have a problem appraising a property because there's stuff inside of it.
Right.
Okay, well, maybe it was an inspector then.
Okay. Yeah,
doing
an
the
inspector could possibly do that. But did you have a contract on it for sale?
No, not yet.
Yeah. So
because we went to. There's some things that needed to be done, and so we had some of the stuff done, some plumbing, a new water heater, a new roof, shingle roof. We had that done, and those are pretty much the main things that needed to be done. So we have, I think, a few more things to have done, and then we'll be good to go. We want to kind of get it up instead of selling it just the way it is. I mean, we fixed up the roof, that kind of thing. We can get more money, basically.
See, this to me is the facts versus feelings type situation. Mm-hmm. She needs to do what she has been authorized to do and what her responsibilities are, and stop feeling some kind of way about her sisters. Yeah. And just go on and do what she's got to do. I mean,
gotcha.
Is she guided by an attorney, or is she just doing this on her own?
I think she's. Put it this way, I think she's consulted attorney.
Mm. Yeah, but they may not be on the case with her because, exactly. I mean, I'm the kind of individual, I work with my client through their entire probate process because, gotcha. Yes, it can be emotional, but you have a duty and responsibility to the estate, not to the heirs.
Right. Understood.
Yeah.
All right. Well, hey, I'm going to talk to my sister today and the executor, and then we got to get this moving, Yeah. It's been 2 years.
Because there's also tax ramifications that you need to know that you're going to be liable for, you or the estate is going to be liable for, because what people don't know is that if there was a homestead exemption on that property from the time that person passed away until now, however long that is, the counties go back and reassess it without the homestead exemption, and you're paying more money as it drags on because they're going to go back and reassess the property, and you have to pay that when you get ready to sell it.
Gotcha.
Yeah. All right.
All right. Well, hey, thank you again. I appreciate it. I appreciate you also, Mary Gill. It's a lovely show. I enjoy it.
Thank you so much. I appreciate it, Johnny.
Have a good day.
All right, 404-726-1380, guys. Questions, comments? We have a couple callers holding. We'll get to you right after the break. Real Estate 101 with attorney Althea DeBar-Johnson. Back in a minute. We're back, everyone. Good afternoon. News and Talk, 1380 WAOK. Real Estate 101, Mary Gill with Althea DeBar-Johnson, estate attorneys of Atlanta. We're going to go to phone lines and talk to Ernest. Ernest, how you doing, sir?
Mary, I'm doing great now that I'm talking to y'all.
Yay.
Hi, Ernest.
Hi there. Long time no see and talk to, Miss Johnson. Last time I think I spoke to you directly was either at Mary's event or a Rob Wilson event a few years ago.
Okay.
But, well, it's my Saturday consultant hour here, so I've got to get my consulting question in while I can get them in there, as they say on the quality info sheet. Let's say we have a scenario. This is a actual scenario there, just over years of looking at different things coming and going. You have a husband and wife that have two sons. They own a house free and clear, and if one son passes away, he's out of the picture there. Then the husband passes away, and the wife eventually passes away there. And then the last remaining son passes away without any of them having any known children there, the two sons. What happens to the, I guess what you call it, the derision or whatever the process there, title for that piece of property? If there are known cousins there, either father's side or mother's side, either one there. What happens to that piece of property in terms of the title and the process of probate and the estate? That's my easy question for today.
Okay, so Ernest, I take it that neither the husband or wife had a will.
Correct.
Okay, and did any of the children, any of the sons, did they have any children?
No children, no will.
Okay, the siblings of the husband and wife, are there any?
Yes, there are, but I'm not sure of the status on them. They're in terms of how many, or I guess for my answer there, because this is for me learning something new. I like to learn stuff here from people that know stuff. I don't like to be the smartest guy in the room all the time.
Sure.
So, but in a scenario where there are surviving siblings of the parents, and then in the scenario where there are no surviving siblings, but they did have siblings, which would produce cousins to the two offspring or two sons that both passed intestate.
So what we're trying to accomplish is finding some heirs at law that will be able to take this home or this asset without eventually going to the state of Georgia. If one of the husband or the wife had surviving siblings, then that property would go to the siblings of the husband and wife. And also, it depends on who died first.
That's what I was going to ask you.
Yeah.
That's what I was going to ask you.
Yeah, husband first, then the wife, then
the husband first.
Actually, first was one son, then the husband, then the wife, then the remaining son.
Okay.
There.
So the wife survived the husband. So
correct.
So since the wife survived the husband, his interest eventually
wound up with her.
Will go to her and the surviving son. Okay.
Correct.
Eventually, because I don't know if there was a probate ever established, and if it hasn't been, some of this would have to be established, Ernest. But technically, the husband interest would go to the surviving wife and the son. Now that they are no longer alive, who else can we get this asset
the cousin.
to?
Cousin.
The cousin.
Right.
Right, a cousin there. So now would that cousin have to file probate for all four or all three, or just the remaining, the mother and the intestate son?
The husband should be probated, and the wife interest should be probated. Those two should be probated because we can again establish the fact that now the sons who didn't have any children of their own, that's where those heirs stop, and we need to find someone else in order to pass on the property that belonged to both of these heirs.
Is this here in Georgia?
You mean the situation?
Yeah.
Oh yes, it's this is not one of my transactions here, but it's one that I'm aware of that had occurred, and that's I don't know where they are in terms of the whole process there, but if it would take half a show to explain all the ins and outs because there are people who committed deed fraud they knew there were no heirs. They filed a quitclaim deed from the deceased son, the last one there, who these people, I mean, these folks, they ain't got good sense. They filed a quitclaim deed and dated it after the date that the guy was deceased.
Yeah, that's great.
Gosh.
I love that.
Some people you just need to walk by and just slap and keep moving.
Here's the thing. I love when they tell on themselves.
Oh, yeah.
Right?
Exactly. And then they claim that it's all legit, and then the notary that signed I mean, I don't like
They
people
could go to
who
jail.
Yeah,
Exactly.
absolutely.
And so it all blew up there and into some kind of mess. And I haven't been able to find out who can tell me the end of the story. So I just wanted to get some quality legal opinion as to what might theoretically be the net result of all of that there. And if I ever run into that again there, I'll at least have an idea of how to handle it and who to send it to. Because on a case like that, see, that's clearly one where I have to call Ms. Johnson up. Hey,
Yes.
I got one for you. Let me know when you get it done.
Well, in my mind, Althea, it would be the cousin who needs to go step up and file
Absolutely.
probate because they should be the receiver ultimately of the property, but it has to be done properly. So the cousin
Right.
should get it, but you can't wait too long for that to happen. Everybody sits around and acts like, well, in 10 years when I feel like it, I'll just do it. It just doesn't work like that.
No, it doesn't.
Now, you've got more, if you, in a situation where, let's say you have more than one cousin, let's say one on the mother's side and one on the father's side there, is it a race to see who's first or?
No, it's not a race.
Father's
to see.
out, right? The father's side is
father's
out.
side is out.
Okay, father's out. So it's now down just to the mother
Side.
there. And then if she's got let's say three siblings and it's three of them that are three cousins there.
Yep.
How does that one duke out?
They will all have an interest.
Okay, so if they all have an interest, they would need to decide who would be the one to file and administer the estate if they can agree on
They need
which
to
one of
agree.
them.
They need to agree, or else it's going to
Right,
be
that's
more
what I'm saying.
problematic.
They need to agree.
Right.
Mhm.
But if they are in dispute, then it winds up coming over to the tax sale, right?
No, it could go to the county administrator to resolve that estate.
But then they get a lot, in my mind, out there, they would get a lot less money because there's people who are now chunking that away for their fees and things like that. So,
But see, the only other thing too about this is that most times the courts will require, if you are trying to become an administrator, they require you to get a bond and to get bonded.
Right.
A lot of times our folks can't get bonded because if they have financial issues or they have bankruptcy issues,
bad credit.
bad credit.
Oh man.
So I guess they need to
Right.
sit. They need to sit down and
Right
pick who's the best one to get bonded. And if it's a small little county and the property isn't worth that much, but it's still worth it to do it, then it might not be that much of a bond. Right. Right.
Mhm.
So
Okay, so the bond is based on the property value or
Value of the estate,
quote-unquote
right.
entire
The value
estate?
of the estate.
mhm.
Okay. All right. Well, once again, I get $1 million advice from $1 million.
Thank you. Thank you, Ernest. We appreciate it.
Hey, anybody out there that ain't listening, y'all ain't learning.
Thank
Thank
all I
you.
can say.
All right. Okay.
All right. Next hour real estate information there is on this station at this hour from noon till 3.
Thank you.
Saturday.
I appreciate that.
All right.
Absolutely.
Thank you all, though.
Thanks, Ernest.
All right. Bye-bye.
Bye. All right. 404-726-1380, guys. Get your questions in. We have attorney Althea DeBar-Johnson. And back, everyone. Good afternoon. News and Talk 1380 WAOK Real Estate 101. Althea DeBar-Johnson is in the studio, Estate Attorneys of Atlanta. So, Althea, I remember this song as being one of the first R&B gospel songs that came out. And we were like, what? They did that, right? They
Yeah.
did that.
Yeah. Chris has us jamming over here.
Mm-hmm.
I love it.
Oh my gosh! And then I think that put the Staple Singers on the
map.
right?
Mhm.
Mm-hmm. Let's go to phone lines, please. Let's talk to Todd. Hello, sir.
6th grade, Pop Staples was still alive. I saw him perform that song. So I have a question.
All
There's
right.
two. I'm not pretending to be an attorney. That's why I'm asking you about this, but I am going to give my opinion on the first one. This is a California issue, not a Georgia issue. $73,000 was allocated out to this man's grandchildren in his will. He included his step-grandchildren as well. However, he put a stipulation in the will that if one granddaughter, who happens to be the by law daughter of a friend of mine, does not pass 2 DNA independent tests, then she will not get that $73,000. It goes to her father, and then he could do whatever he wants with it. And she didn't pass them. She didn't pass the DNA test. That's not his real daughter. And he made the decision that I'm not giving her the money. She's got all the money she's ever going to get from me. I was tricked. Now, the mother comes forward and says, but she is by law, because he did sign a paternity statement, that this is my daughter. But he always questioned it, and the grandfather made that stipulation in the will because his son, contested it. If this was a Georgia matter, how would this be handled? I mean, to me, that's his will. If he says those are the stipulations, that's his will. But the mother's coming forward and saying, that's still his granddaughter, because that's still hers. That's, you get it.
Oh, we got it.
Yeah.
Yeah. So how would that be handled?
Right. That's the grandfather's condition. He can place those kind of conditions in his will if he likes. And she didn't meet that qualification of being the legal child of his son.
Biological.
Oh.
Mm-hmm.
Legally, because he did sign a paternity statement, even though he's told me for years, and I don't think that's my real daughter. I think I've been tricked. But he did sign a paternity statement. The grandfather doesn't have anything to do with that. He's like, nah, if my son was tricked, then you ain't my biological daughter, so I want 2 independent tests of DNA, and if you don't come up biological, you can't have his money. It's going to my son. So that's his will, right? They can't.
I mean, that's his will, but you have to go back to the establishment of a legitimate child, a legal recognized child by the father. And if there was a paternity or a legitimation of this child, then that's the legal child of this gentleman. Okay.
Well, so now,
but do they have to make the grandfather's estate turn over to 73 grand? She's 20 now. She might be 21. But do they have to make the grandfather's estate turn over that 73 grand to her, even though he put in the stipulation?
See,
She's
Althea,
not my
I
biological
disagree
granddaughter.
with. I don't think so. I think Todd's right. I think that if I put in my will that they have to have a DNA test, regardless of whether or not you legitimize them, they have to have a DNA test to prove that I'm blood in order to get a part of my estate. I don't think that has anything to do with the mother's claim that she was legitimized. It has everything to do with the, blood relation that the grandfather put in. It's like me. If I put that in my will, I don't expect someone to come and say, oh, well, we legitimized her. It's like, no, I want my money to go to my legitimate blood grandchildren. And that's it, even though I don't feel that way personally, because I do have a bonus grandson and I love him the same. And I would not ever make a difference between any of my grandchildren, regardless of what your legal blood status is. I think that's not right. But regardless, legally, he put that in there for a real reason out there.
Yeah, he did. And there's nothing wrong with what he placed in his will. He placed that condition, biological. Sure. I got that. She may not have a leg to stand on. I'm just looking at it from the fact that he legitimated her. So technically, legally, that's his child. Legal.
That's true.
From a
Legally.
legal standpoint.
But
the
it's not
grandfather yes, don't have any. The grandfather said biological blood heir, heir-in-law blood heir, and so that does make a difference.
Okay. So that's question number one. And again, that was motivated